Hi everyone, welcome to Ethics in Practice of Professional Engineering Part 2 with Kevin Sido and Elyse Ryan. I just have a few quick reminders. First one being this is the second part of ethics. This one's going to be primarily meant for those of you who were licensed in Wisconsin, though this can also qualify as a general PDH for those of you who aren't. I do have the handouts and the quiz available up on our website. There are two additional handouts that Kevin and Elyse wanted you guys to have along with the presentation. All three of those are up on our website along with the quiz. And I don't know if you guys can see the handouts tab on your dialog box here, but I can't. So I posted that link again in the chat area. So if you follow that link that's in the chat area, that'll take you to our webpage as well. If you guys could complete the PDH or the quiz for the PDHs by Monday, I will get those certificates out to you by Tuesday. Like always, we'll save questions for the end. If you guys have any questions for me or any of the ISPE staff, you can send an email to info@illinoisengineer.com. And from here, I'll let Kevin and Elyse take it away.
Thanks very much, Ariana. Kevin Sido here, and my colleague Elyse Ryan, and we'll be speaking today about ethics for engineers with, just as Ariana points out, the emphasis on Wisconsin, some Illinois, and maybe a fragment of Indiana as well. Our bios are at the end, and you can check that out at due course. We've got a lot of ground to cover here today, and as Ariana points out, we'll have some questions here at the end. So, you know, when we talk about ethics, and those of you who have seen my programs in the past, you know, I have this introduction here reminding everybody about ethics and its importance and its requirements under state law. The real question for all of us, though, whether it be lawyer ethics, accounting ethics, and certainly engineering ethics, is can we spot a problem when it arises, and will we correctly respond when that challenge arises?
And we've listed some of the learning objectives here for you. You can review up on the slide. Essentially, our goal with this presentation is to get you all comfortable with the ethics rules and a sense of purpose, the purpose behind those rules, and as Kevin said, sort of how to comply with them. We've listed here some sources of Illinois PE and SE ethics laws. Also, please take a look at those at your leisure and read them to get a better sense of where those are coming from.
And of course, you know, you can go to the Department of Professional Regulation website, and with just a little bit of nosing around, you can be directed to those. And it's amazing what you can see when you start reading this stuff online. For Wisconsin, I point out here chapters A-E, 2, 8, and 13. Wwisconsin has a situation where they lump together architecture, landscape architecture, professional engineering, designing, and land surveying all into one broad category. Probably just as well, maybe someday Illinois will do that, but for now, this is where you'll find them. Section 2 deals with sealing, drawings, and branch offices. 8, which is where we'll concentrate, deals with good practice and ethics. 13 talks about continuing education. Some additional sources are such things, of course, as administrative actions, even court decisions. It's very rare that a case on an ethical violation, whether it be Illinois, Indiana, or Wisconsin, or for that matter anywhere else, goes up to a court for an actual decision. It's just a rare thing. But on the other hand, of course, when the court says this is what those words mean, well, that obviously is the strict governing result.
Now, many of you may be licensed in multiple states and coming here with the question of, do I have to be aware of the laws in all these different states where I'm licensed? And the answer to that is yes. You should definitely be aware of laws of other states where you're licensed, and the key question is what happens when you're disciplined in one state? How can that affect other states where you're licensed? And the answer to that is that other states are clearly very interested in disciplinary actions against you. Wisconsin, the most notable thing about their rules in terms of notification is that it must be done within 48 hours. So if you are disciplined in another state and licensed in Wisconsin, you have 48 hours to notify Wisconsin in writing of that disciplinary action. In addition to that, you need to attach all papers and documentation showing your the ruling of the disciplinary committee or what action was taken against you.
This is a very strict rule, and I'm not aware of this having a counterpart anywhere else, certainly not in Illinois or Indiana. I've looked at the rules for Minnesota, for example. It's not there either. So this is an opportunity and a requirement to really be very, very, very careful about such situations. One thing I'd like to talk about that a lot of people seem to kind of overlook is this idea about somebody being licensed as a PE in a given state and then acting as though it's, well, extraterritorial. And the question is it, for example, take a PE licensed in Illinois but not in Wisconsin. You want to be very careful that you don't imply through, for example, letters or emails or whatever that you're licensed in Wisconsin. And one of the points I would make is that lawyers, for better or worse, are very much involved in regulatory matters involving engineers, architects, and for that matter, accountants and physicians. And the rules about lawyers not implying they're licensed other than the state in which they are very strict. And you're going to find, or you could find, that that strictness kind of carries over to how they might view an engineer. Now, the most notable case, without a doubt, is the Topaz case. And you can Google it or simply go to that link under leagle.com and find it. It's a quite remarkable decision because a gentleman, Mr. Topaz, had been licensed in the state of Maryland as PE. He then retired, stopped practicing, was no longer admitted to the, I almost said admitted to the bar, but was no longer licensed as a PE in Maryland and had never been in Oregon. Notwithstanding that, he wrote a letter to the Oregon Board of Examiners and signed it with his name, comma, PE. Make long story short, they fined him $350 and he took the case all the way up to the Oregon Appellate Court, and the Oregon Supreme Court would not review the decision. And let's just say that gentleman got into a heap big amount of trouble by suggesting he was a PE in Oregon when he never had been. And so my point about this is that you might say, well, once I'm a PE anywhere and at any time in all places. And the answer is no, not so. It's not like a degree where doctors put MD after their name and go anywhere and everywhere with that designation. It's just not that way. Now, one thing that's a progressive point is that Illinois PEs can opt for a designation by statute that says, you know, like John Jones, Jane Doe, whatever, professional engineer, comma, retired. And you can do that. But that doesn't exist in Wisconsin, and it doesn't even exist so far for Illinois SEs. One thing I'd point out too, of course, is, and you can look at this at your leisure, but common sense. You just cannot overlook that when it comes to ethics.
We've listed here for you as well some more unofficial sources of ethics rules. These organizations have listed their considerations of ethics rules and their interpretations of them. And, you know, for example, we've listed NSPE. And the NSPE is an unofficial source. And one thing that we want to stress that's very important here is that this is an unofficial source. These organizations do not have the force of the law behind them in enforcing these ethical rules, but they are considerations that their members need to take into account. We've listed some sources here for you, websites, et cetera, that you can go and look at these organizations' rules if you'd like. One thing to keep in mind is if you are a member of one of these organizations, obviously you're going to be expected to have to comply with these rules. And breaking one of their ethics rules, though it doesn't have the force of the law behind it, may result in you being kicked out of this organization. You might be written up in the magazine, for example, and showed that you're being tarred and feathered and being kicked out. So you'd want to keep an eye on that. Again, the NCSEA also has unofficial rules, And because it's so important, we'll say it again, these do not have the force of the law behind them. But if you are looking for sort of the higher standard of ethics, you can review the sources that we've provided these organizations that they have.
So the question arises, just how far does an engineer's ethics really extend? The ASCE did a column in its monthly magazine that even talked about keeping employees on board when management decides to close a branch office. Wow, I got to say, that seems pretty extreme to me. Of course, you know, you could read the article, but what about this one, though? This one, to me, has a far, far more immediate and practical concern. Do engineers have ethical duties to report imminently dangerous job site conditions, even if they have no duty under their contract? Well, there's a very famous case decided by the New Jersey Supreme Court, and my partner, Dave Ranich, if you were on board with us last week, a week ago today, he talked about that, and it's a really tough situation. Most people think that there is not a legal obligation to report, and then the question is there an ethical duty? And we'll talk about this more as we move along, because the statutes in Illinois, Wisconsin, and Indiana make it very clear that public safety is everything.
Now, many of you also may be thinking that disciplinary action and ethics go hand in hand, that they're essentially the same thing, or that they're different things. But in reality, they may be treated the same in the eyes of a regulator. For example, you may think that the failure to file a tax return or the failure to pay child support has nothing to do with your ethical obligations. But you should be prepared for regulators to treat those in the same manner. And they can consider that the failure to pay child support or something to that effect is an ethical obligation that you may not have succeeded on.
Well, in preparing for today, Elyse and I were sitting in my office and we were looking at one of the Wisconsin rules, which we'll come to, and we were looking at it and saying, wow, if you don't even pay rent on time, you could, in theory, be hailed before the board. We'll get to that. So when we're talking about general propositions of ethics, these are really three very important takeaways. One is, ignorance is no excuse. You probably knew that. The practice of engineering is a privilege, not a right. And public safety is paramount. So why do we have written rules if some of these are common sense? Well, for one thing, they want everybody to be able to be prosecuted if the need should ever arise. They don't want somebody to say, oh, I didn't know that. So sometimes they write down some rules, for example, no kickbacks, as if somebody would somehow think that that would be ethically appropriate anyway. But the real concern, though, is watching out for rules that establish technical points that are beyond simple common sense. And we've already given you an example of that with that 48-hour rule in Wisconsin. Who would know that if she hadn't read that rule or listened to our program here?
And another thing to be careful about is, what if there is no specific written rule? It may be tempting to think that if there is no specific written rule, then you have no specific ethical obligation. But what you need to watch out for are these catch-all provisions that may apply. In Wisconsin, if we look at AE 803.3, specifically in Section C, this is what Kevin and I were discussing when we decided that under this provision, it's vague enough to where if you were late on rent, that could be considered misconduct for which you could get dinged.
And in particular, subsection C of 803.3 says,
engaging in conduct which evidences a lack of trustworthiness to transact the business required by the profession.
Trustworthiness. You know, that seems like a wonderful goal, and it's certainly something we should all aspire to, but wow, it just seems to me that we could be caught in a difficult situation.
And another thing that we want to stress here, just because it's important, is public safety. Public safety is paramount in the eyes of every state, and certainly yours too. So when interpreting these ethics rules and determining if you have an obligation, it is always paramount to consider public safety.
So my rule on the rules is, in cases of disaster, the worse it is, one can expect the keener the 20/20 hindsight to become. Last week we talked about the Florida pedestrian walkway collapse. And one can only wonder how that engineer that made the report by leaving the telephone message might be considered, might be scrutinized, I should say, might be put under the microscope, given the fact that there was so much injury and death that resulted from that. All a very interesting situation. One thing I thought about doing, but frankly didn't get the time to get accomplished, is to suggest a link to a wonderful article in the New Yorker magazine, The 59-Story Crisis. Maybe some of you have read that, and it's just an amazing thing about ethics in the situation and what can happen going forward, and how public health and safety is so much an emphasis. One thing to remember here is that the license or the registration is yours. It's of course transferable if you switch employers. It's an incredibly valuable thing, but it's yours. It's not your employer's and it's not your client's, and it's not to be loaned out just to meet temporary needs. So for public health and safety in Illinois, we have this situation that your judgment is overruled when safety and health is endangered. You're to notify the client or public employees. We talked about this last week in connection with, for example, the Florida collapse. Now, in that instance, the engineer's professional judgment arguably had not been overruled. He was just pointing something out. But it still is really important to know about, because this is where somebody can come back after the fact and say, well, why didn't you notify us? Wisconsin doesn't have that strong, stringent language, but many states do. For example, Florida has language which is very similar to the Illinois language.
When we talk about ethics on seeking new work, this slide actually lays out sort of a summary on this topic. We can't go through all of these in detail because, again, we do have a lot of information to cover in a short period of time, but take a look at those. Please read them over. When we're specifically talking about seeking new work in Illinois, the three major points to consider really with seeking new work in any state are competence, truthfulness, and your capabilities. Again, in Illinois, in this slide, you see that you can only undertake assignments if qualified by education and experience in that specific field. Now, Illinois does allow for the undertaking of assignments outside of competence, but only if you restrict your personal contributions to your area of competence and have others who are competent in those areas in which you are not perform those tasks. So again, three things to consider are competence, truthfulness, and your capabilities. Now in Wisconsin, you still, again, this is provided with a fairly straightforward rule. You need to accurately and truthfully represent to a prospective client or employer the capabilities or qualifications which the registrant has to perform the services to be rendered. Again, very important here that you don't oversell or maybe exaggerate your qualifications in an area, but that you are truthful about your capabilities and your ability to perform certain services.
So, for example, in Wisconsin, it says that you can't offer to do the work, but you can do so if you have a person on board who is qualified. Now, they say without retaining the services. I suppose that could be, of course, a person within your same firm, but you may have to subcontract matters out. So, for example, like here's a simple example. A PE who's really strong on the civil side realizes that the project is going to require a structural retaining wall, and appreciates then that that person may need to retain an outside structural engineer to do that. Perfectly appropriate, but what they're doing very much is trying to avoid people struggling, or as we used to call it in our law firm, dabbling in areas that you might hold a license for, but nonetheless are truly not really qualified or experienced enough in to do it correctly.
And as Kevin described, you may think it's common sense to not say that you do dabble in other areas or that you should not misrepresent or exaggerate your qualifications. But again, it's so important, and that's why this is specifically written in Illinois, seems very obvious, but don't misrepresent or exaggerate your degree of responsibility or competency in certain areas that you may not have that qualification.
Just think about this quickly. So there's a collapse, there's a problem, there's an electrocution, there's something or another, and now they're coming back and looking at you. You're now finding yourself under the microscope, and they're saying, you know, we looked at how you got that job, and we think you exaggerated your prior assignments or your qualifications. And now suddenly the room is getting very warm, and you're feeling like you're under the spotlight. Definitely
a situation that you do not want to be in. Another situation that you do not want to be in is accepting a kickback or payback for a job. Again, specifically outlined, even though this may appear to some of you as common sense or fairly obvious, but you cannot offer to pay either directly or indirectly any commission, political contribution, gift, or other consideration to secure professional assignments. So no bribes, no paying or contributing to political campaigns in return for a promise that you will get a certain job.
So this becomes a really tough situation, and we talked about this last week as well. Dave brought it up, and that is, so you're doing work for a public body, whether it be the village or the sanitary district or something, and people buttonhole you and say, you know, we'd really love it if you bought a $500 ticket to our fundraiser, whether it be re-election or what have you, and, you know, is that a political contribution? And notice the words here, to secure professional assignments. And somebody might say, well, why else do you think you were making that contribution? And yet somebody might say, well, there was no strict quid pro quo. It's not like the elected official gave me a wink when she said, I need some contributions. And yet, on the other hand, this is kind of a dicey situation. We have the strict wording, and yet there is what some might call reality. Wisconsin talks about this on referral fees. I've got to say, I'm kind of frankly surprised with this wording where it says you can collect a referral fee if you give written notice to all parties concerned. I just kind of find that a bit surprising.
As lawyers, it'd be tough to send a letter to every single person involved saying, just so that you know, I'm getting a referral fee for this work, but that seems to be the way that this is phrased.
Well, right. I mean, I suppose, well, we won't get into the legal side of it, but just to say, we don't see an Illinois counterpart or corollary to this Wisconsin rule. So on seeking new work, you know, puffing is a word that can be where one speaks highly of her credentials or his credentials, and the law accepts puffing. That's what they call it when you're saying, you know, I work at the best law firm in Chicago, or my engineering firm has the strongest qualifications to do this job. That's considered puffing, and it's sort of like, you know, that just kind of goes with the territory. But, you know, my point is, what will your competitors say? Because, quite frankly, that's where I believe your work can come under scrutiny, is somebody says, you know, I just had it. That other engineering firm is just exaggerating all the time, and they just don't have the qualifications that they say they do. They haven't worked on 16 structural assignments for new schools or whatever. That's where I think you got to watch out. Now let's work or let's look at a different thing. Seeking new work, but replacing the original structural engineer. NSPE is the National Council of Structural Engineering Associations, and their code of ethics says that the structural engineer should decline an appointment to supplant the original engineer when doubt exists regarding the resolution of outstanding matters. So maybe there's a fee dispute between the client and the original SE. Under NSPE, they're telling you don't take on that job. Now, I would suggest to you that is a higher standard of ethics, if you will, than Illinois, Wisconsin, or Indiana requires. And as Elyse said earlier, NSPE is a wonderful thing, and yet it does not have the force of law.
Now let's change gears and talk about peer review assignments. The main question here is it ethical to take on a peer review assignment?
Well, broadly speaking, the answer is certainly yes. But now I'm going to bring up for you for consideration the National Society of Professional Engineers. And they have ethics, and they say that an engineer shall not review the work of another engineer except if that engineer knows or the connection has been terminated. I must say that this is not the ethics for lawyers, not that that makes anything, but it's not at all unusual for clients to go to a different law firm, whether it be in divorce cases or you name it, and say, you know, I'm not so sure about how my case is going. Elyse, would you take a look at it? Tell me what you think.
Proceed with caution.
Well, that's right, certainly with engineers. Now, NSPE says that if you're an engineer in government or education or whatever, you can look at the work of other engineers. Gee, thanks. And ditto for sales or industrial employments, you can look at other products and talk about it. This is a very rigorous standard in my judgment, and yet there it is. For NSPE, that's a rule that they're looking for you to follow. If you are going to do peer reviews, and they're perfectly legal in Illinois and Wisconsin and elsewhere, you want to be very, very careful that you've got a crystal clear scope. My experience has been that the clients of the world are looking for peer reviews on the really tough engineering judgments, not the routine plays. And so they come to you and say, well, we'll pay you $200 an hour. Well, all right, $260 an hour. Would you look at this really difficult issue that we have arising on this project? We figure it'll probably take you 3 or 4 hours total. Suddenly now, you've got the really hot potato in your lap. You're going to get paid a couple $1,000s if you're lucky. And what kind of liability are you taking on for that, just to have your ego stroked about being asked to solve a very difficult question? And watch out for the duty to report if a problem is discovered, because that may be why they're coming to you in the first place. They're not sure where to go, what to do. Let's talk about sealing documents. There's a lot that could be said. We could do an entire hour just on this. And we have questions, of course, about, well, what's supposed to be sealed and where is it to be sealed? Is it the front page, all the pages, some of the pages? What level of supervision do you have to exercise? Recognizing that in any kind of an efficient world where there's many employees at a firm, maybe it's the boss that's doing the sealing, but the question arises, though, how much supervision does the boss have to give? And can you ever succeed to the work of another engineer? That's a very dicey situation that is not necessarily so obvious. And then lastly, what about copyright issues? Which copyright is something that is not in the ethical rules and not in the state rules at all. Copyright is a federal notion or a federal statute on point on that, and that's what governs copyrights. So let's kind of go through some of this. The Illinois Professional Engineering Act talks about technical submissions, which are such things as drawings, specifications, but they also include reports. I once had an engineer say to me, well, if I don't seal the technical submissions, that means I can't be sued for malpractice, right? Well, I think we know the answer to that. Of course you can be sued whether you've sealed it or not. And you know, you're supposed to seal documents under your direct supervision and control, not indirect, not remote. The SE Act has slightly different language. They don't have a reference to technical submissions, but it's otherwise pretty much the same. They refer to plans, drawings, and specs. They don't mention reports as such, but I think that you should be prepared to seal reports. And again, we see this matter about safety coming forward again. And we see this matter about competence. Oh my gosh, if there's any couple of takeaways, it is how safety, safety, safety is so important, and then competence as well. The PE's license covers everything from electrical to civil to fire safety to so many different things, designing, investigating, but the idea has to be competence. Now, plan stamping, you know, of course, everybody knows that plan stamping in the old sense of the word was and always has been illegal. So the contractor walks into your shop and says, you know, I drew these up, you know, I went to engineering school, this is really easy, it's just a, you know, a standalone strip mall kind of a thing, how about $100 and you put your seal on there so I can go get a building permit, and all right, $200 then.
Wink, wink.
Yeah. Well, I mean, I think everybody knows that just does not work. And in case anybody had any doubts, well, there's the rule. This is an example where they can trot that out if and when somebody is found to have done the plan stamping. Not surprisingly, Wisconsin has a similar situation. And again, it's referring to the personal direction and supervision. Now, they have a small caveat there that if you're working for another PE under her personal direction, the supervising PE can stamp. Well, that makes sense, because even if there was, let's say, a draftsman who was drawing it up, but under the supervision of the PE, I mean, everybody knows that that works. Wisconsin, though, unlike Illinois, has a rather long definition of what is supervision. And in the handouts that we've given you, Rule 8.03 goes through that, actually in quite some detail, about what is supervision or direct supervision or responsible charge or direction and control. They define all of those terms. And then they say it includes this, and they have 5 things. And there's also 5 things that is not adequate supervision. For example, if you lack the technical proficiency yourself, you shouldn't be supervising. Seems obvious, but there we have it. The question arises, what about sealing the work of others? Now, this is a rather technical situation here, because the Illinois PE rules and the Illinois structural engineering rules are different. So on this next several slides, you'll see some definitional wording here. And for the PE, if the licensee is unavailable to complete the work due to death, incapacity, relocation even, a successor licensee can take responsible charge, and it goes on to say, by doing this, doing this, doing this. Let's talk about SE then. So unlike the PE one, there is not a requirement about unavailability. You could just simply substitute for another structural engineer, so long as you've sufficiently reviewed the documents to make sure that everything is fine. I say that very broadly. You know, you got to do the calculations, redesign, and on and on and on. Just think about this just for a minute, though, and compare this to what we told you several slides back about NSPE, where they're saying, don't be doing that. Or NCSEA, don't be supplanting the original person, whereas here, the SE in Illinois, granted, has to do the calculations, redesign, and you're taking on responsibility, but there's no ethical problem in doing it. You just have to follow the statutes. The takeaway here is that if you get one of these situations, do not wing it. Go to the statutes and the rules and read it carefully. Wisconsin has a rather technical requirement here, and we've provided this in 2.028 and it goes through it. In fact, like the last bullet point, if the PE were registered in Wisconsin, but you're sealing it, you have to say why the original architect or PE is not submitting it. And it's kind of interesting because why did they back out? You know, did something happen? If they died, that's one thing. But if they've just decided that they got cold feet, well, they want to know about that. Let's move on to copyright here quickly. One thing that you want to remember is copyright law is not the slightest bit affected by these state laws on successors. Just because you've complied with state law doesn't necessarily mean that you can take or infringe on the copyright of another architect or engineer. Here's the key takeaway here in the italics at the bottom. We didn't talk about Illinois architects, but I can tell you that is even still different yet than what we talked about for Illinois PEs and SEs. The effective sealing, well, no surprise there that your work was done appropriately with these standards. No counterpart in Wisconsin. Sealing what pages? Well, you can seal the cover page and then you would seal the individual portions of the technical submissions. Indiana, and we'll talk about this next week, has a much better way of saying it. They say, go ahead, seal the cover page, but indicate right next to your seal on the cover page the pages that follow that are representing your work. So if you're doing the electrical engineering, maybe you seal the cover page, but you say then sheets E1 through E6, and no one can confuse that for a minute with mechanical, structural, civil, or something else. And so everybody knows that you seal the individual portions of the technical submissions. And this is what I was getting at here with Indiana. The key part there indicating what exactly it is that you're doing. Wisconsin has a slightly different take on it. Yes, everything has to be signed, sealed, and dated. That's no surprises. But notice this second paragraph here about the need to clearly identify the other sheets in the bound set. This is really important for tort liability because if your seal is affixed and it makes it seem as though you've done more than what you think you have, you could find yourself on the short end of the stick in a lawsuit. Okay, let's move on finally away from seals and get into speaking out into the public, whether it be through a report or literally oral opinions, interviews. I've summarized this very briefly because we covered it last week, and that is, well, of course you have to be truthful. And as I said, the truth, the whole truth, and nothing but the truth. You can't hide for whom you are speaking. You can't make it seem like you're just some engineer that's been pulled off the street who happens to have these glowing reports. And then here's one that I think a lot of people tend to overlook, and that is the importance about being informed before you would speak. This means, for example, that you would want to be very cautious about being interviewed by a television reporter who asks you to stand in front of a job site and comment on why you think that the construction collapsed. Now, maybe a lot of you saw the 60 Minutes program where they had that magnificent tower in San Francisco that has some concerns of settlement. And the structural engineers who were interviewed there, I was listening very carefully. and I would say that they walked the fine line, I think, about being informed before they were interviewed and being careful not to voice opinions about which that they had not really been able to do the prerequisite research. In other words, they in many instances had not seen the drawings, ran the calculations or what have you. They were offering careful opinions to the 60 Minutes reporter who wanted to, of course, try to get them to blurt out some gigantic criticism to make for good television. Let's talk about conflicts of interest.
So there's some key issues that can arise with considerations when you may discover that you have a conflict of interest in a case. And the first thing that we want to emphasize here is disclosure, disclosure, disclosure. There's a reason that we wrote it down 3 times. That is one of the most important things that you need to keep in mind. The other question, an important consideration that comes up when you've potentially identified a conflict of interest is, can you proceed with the work? And in Illinois, you can see that the rule specifically lays out that you must conscientiously avoid conflicts of interest. And that may be the rule, but in some situations you may find that it's unavoidable. And if it is unavoidable, you must disclose, and disclose promptly, to your employer or clients any business association, interest, or circumstance which may influence judgment or quality of services. So again, in Illinois, one of the most important things you want to do is obviously try and avoid these conflicts. But if you do find yourself having to navigate a conflict of interest, the most important thing you can do is disclose. In Indiana, the rule is very similar. Again, you have a duty to inform your employer or client of any potential conflicts of interest. When we look at Wisconsin's rules as to conflicts of interest, we also see that this duty to inform is pervasive against really most states, and that you do have that duty to disclose potential conflicts of interest to your employer or your client. But the interesting difference in Wisconsin is that we have this added component of the rule that states that you do not proceed without the full approval and consent of the client or employer. So now your question in Wisconsin is, can I actually proceed with this work? And if you don't get very clear approval, then you must withdraw if you can't faithfully perform, or if you don't get approval from your client or your employer. And that's a very important different distinction between Illinois and Indiana and Wisconsin laws on this issue.
Okay, so going further with conflict of interest, don't accept compensation unless it's been a full disclosure and consent. Well, okay, that's fine, I suppose. Again, this is a kind of a variation on a theme. Be very careful, and if there's any doubt, make the disclosure, get the consent, get that consent in writing. Very important. Now, I've really managed to bungle this here, so let's quickly, gosh, I thought we were going to do this here without any problems.
No glitches.
Yeah, let's see here. Apologize for this, but we're almost where we want to be. Okay, and I think we're now to this next one here. Okay, one last, let's go back to this one here though about value. One of the things that's important is, can you accept any value? What's the answer, Elyse?
The answer to that question is no. This rule makes it very specific that any gratuities directly or indirectly from any contractor or architect, employer or client is responsible is prohibited. You may not solicit or accept any gratuities or anything of value. And importantly, as we see here in Illinois, there is no threshold here. There's no limit in terms of a financial dollar amount that you could accept. The rule is very clear that you may not accept any.
How about Wisconsin?
Now in Wisconsin, we can look at AE 805E, and what we see in 805E is that you may not solicit or accept anything of value from material or equipment suppliers in return for specifying endorsement on a product. So again, Wisconsin mirrors that language of Illinois, and we see that you may not accept any gratuities or anything of value. And again, there is no financial threshold here. It's just a blank prohibition.
But the curious thing, though, is, so if the engineer then specifies, or I should say, makes it clear that contractor A ought to get the job, and then receive something of value in Wisconsin, arguably this language that we see in AE 805E is almost too narrow, because it's talking about equipment suppliers, but what if you accepted something of value from a contractor who was doing work, doing services? It's
Not specifically outlined.
No, it's not. I mean, and it might be the catch-all. Okay, in our remaining minutes here, let's talk about how to resolve an ethics question. The key takeaway here is bullet point 2, and that is the only person who can give you confidential advice is your lawyer, not your employer's lawyer, certainly not a government lawyer, the people at the hotlines or the national organizations. They'll speak in generalities, and yes, that may seem like a commercial for Elyse and me, but that said, I want you to appreciate that it's a difficult thing. And when you ask your buddy about a hypothetical, ooh, be careful. You may find that they suddenly have been charged with the duty to report you. And that's the question, is there a duty to report?
And when we look at the rules in Illinois versus Wisconsin, we can see that in Illinois, it requires that if you have knowledge of any alleged violation, that you shall cooperate with the division in furnishing information or assistance. So that language is, you know, a bit weaker when we look at, is there actually a duty under this rule to report? All that this states in the language is really that you have to cooperate. In contrast, when we look at Wisconsin, that language states that you shall assist in enforcing laws which prohibit unlicensed practice by reporting violations to the board. That language is very clear and is much stronger than the language that we see in Illinois. So in Wisconsin, there is an affirmative duty to report any violations.
So now let's look at some of the other ethics. For example, NSPE, definitely a requirement to report. Not to NSPE itself, but to the professional body. And here it is again in a different provision of the code. How about ASCE? Affirmative duty to report. If you don't report, you might get kicked out of ASCE. Well, the question arises, though, all this talk about reporting, can somebody get in trouble from a civil law damages standpoint?
Well, it appears that people usually don't take lightly to allegations of misconduct or violations of these rules.
Well, they certainly don't, and the law supplies the remedy of defamation for a situation where somebody has been accused of professional incompetence and other professional lapses. In fact, speaking in Illinois, for example, the jury would be told that damages are to be presumed, that even with no proof, that a person who's been said to be incompetent in her profession, or that he's engaging in illegal acts as a professional engineer, those sorts of things can give rise to automatic damages and a very difficult situation. So defamation lawsuits can clearly result. The question then, Elyse, is what about immunity?
Well, and in Illinois, there is full immunity if you do report a potential violation to the government. So whistleblowers, or those people who may think that a violation has been made and do make that report to the government, to the Department of Professional Regulation or the police, they are given full immunity against any potential defamation lawsuit.
Well, what about ISPE then? What if somebody makes a complaint there?
Well, if they report to a private organization, the complainant must have acted in good faith and be free of malice, which you'll notice is not full immunity, but a bit of a lesser classification. So they must prove that they acted, one, in good faith, and that they were free of malice. So what we call that is a qualified immunity.
And then how about Wisconsin?
In Wisconsin, immunity will exist, but again, we don't see language as strong as Illinois providing that full immunity if you do report to the government. But in Wisconsin, the standard is good faith. So when there's, the issue here, again, when looking at the language between Illinois and Wisconsin, is that when the standard is not complete absolute immunity, you do run that risk of being involved in a lawsuit, which nobody likes. They're expensive and tedious, and when you have a lawsuit, there's really no certain outcome as to whether or not that person could succeed on a defamation case against you.
Absolutely, that's right. We have kind of an irony here then. So in Illinois, we're saying it's a weak standard on the duty to report, but if you report to the government, and by that I mean, for example, the Professional Engineering Licensing Board or the Structural Engineering Licensing Board, or even for that matter, the police, about some job site situation or whatever, full immunity. In Wisconsin, there's a full duty to report, but only a good faith immunity. And that's something that we've seen in Indiana as well. Now, what about evidence in malpractice lawsuits? Can these rules be pointed out as evidence of a failure to practice according to the professional standard of care? And the answer is very much so. It happens in legal malpractice cases all the time. So be anticipating, if you are sued for damages, careful plaintiff's lawyers might read these rules pretty carefully and try to point out that, for example, you as the boss didn't give the requisite supervision because your employee Ajax said that the boss only came around once a week. No, he wasn't really looking at my drawings. I don't think he was really supervising me at all. Can you imagine where that will go? Okay, lastly, I still am indebted to an engineer who gave me this wonderful Dilbert cartoon. And we're about ready for Ariana to ask the questions that we have. I'll let you get back to the Dilbert cartoon at your leisure. And here's me and here's Elyse, your speakers today. Ariana, any questions?
So we have one so far. I'm going to let you guys type in some questions if you have them, but I'll go ahead and read this one. Any limitations on business cards with PE after your name? Can you only give out cards in those states you are licensed?
Well, I think the best way to handle that is, and if you think about it, this is pretty typical for a business card always, and that is you would have your name and your firm and all that kind of thing, and then you would have your address. And let's assume for the minute that you give your name as Jane Doe, comma, PE, and you're licensed in the state that is the address you give on the card. So Jane Doe passes out a card saying PE or whatever, and she lists her address in Springfield, Illinois, perfectly consistent. And if she goes to a conference in Madison, Wisconsin and hands out her card, I think that's perfectly wonderful too, because there's been no, shall we say, deception suggesting that they are licensed in Wisconsin when the address shows Illinois plain as day. If there isn't an address, though, I think that gets into a problematic thing. And I could talk for 20 minutes on this next point, and that is an Illinois licensed structural engineer, and that person is working, well, say in Madison, Wisconsin, shows Madison, Wisconsin as her address, and then says Jane Doe, P-E-S-E, and somebody said, gee, I didn't know Wisconsin licensed structural engineers. That's the question. That's another 20 minutes. The simple answer, though, is show your registrations consistent with your office address. That's what lawyers do. When lawyers are at the regulatory offices, that's what they'll be looking at.
So that's the only question we have so far. Kevin, is there anything that maybe you want to expand on for the next few minutes in case people are still getting their questions in?
Well, I would say definitely watch your membership in these organizations like NSPE, ASCE. They are tremendously important for the profession. They speak for the profession in Washington or Springfield, as the case may be. But just be mindful that the ethical codes that they have don't have the force of law, and yet you want to still be very mindful of what they are, because if you've joined that organization, you're trying to practice at a level above, shall we say, the ordinary. And that's really an important thing. You know, we talked last week about the duty to speak up, and I think that that's something that is really, as I said earlier today, will you be ready to correctly respond when the challenge arises? And that, to me, is as good an example as any. Do you appreciate when the chips are down about the need to speak up and keep speaking, and not be put off when the employer or the client says, "Oh, I'll take care of that. Just don't worry, we'll get to that." And to weave in another important point, it's your license, and you're the one that's going to be suffering greatly if and when something happens, and somehow somebody wants to say after the fact that you just didn't say enough. You maybe blew the whistle, but we couldn't hear it a mile away. You just needed to speak still stronger and longer and harder and with greater emphasis. Some of these ethical things are some technical rules about the business about sealing documents. When a person is licensed in another state, one advice I give my clients is to be sure to read the rules when you walk into that other state. Because, for example, at a bare minimum, when you're in Wisconsin, you want to call yourself a registered PE and not look like a carpetbagger or a yahoo and call yourself a licensed PE like we do here in Illinois. Ditto for Indiana. Small things can make you look and have that higher degree of competence and just look that much stronger all the way around. Elyse, any comments?
I think that about covers it. I will say that Kevin referenced that 59-story crisis article, and that actually is a fascinating article in terms of, you know, a situation you may be in where you realize that a mistake could have been made, and how you can alleviate that mistake in a way that is consistent with the ethics rules, but, you know, also tries not to highlight, you know, something that may be a potential mistake before you can actually do the work and determine if a mistake was made.
And one of the things in that article that I thought was very telling is that the engineer conceded for just a little bit of time, he wondered, did he have to report it or should he report it? Can I just kind of, well, maybe get by and maybe nothing bad will happen? And of course, he shook himself out of that, made the reporting to the client, faced the music, everything was fine. And yes, a professional liability claim was made, but it didn't cost him anything more than his insurance policy, thank heavens. But everything worked out okay at the end. Excellent reading if you haven't read it.
Looks like we have one more question. If a client offers tickets as a reward for a well-done project after the completion of the project, is that ethical to accept?
Ooh, that's an interesting question.
Well, you know, I think it is, because it's the completion of the project, and it's not, shall we say, a quid pro quo for either choosing somebody or selecting or specifying something. And arguably, of course, it's only, as the question points out, a reward. So I don't see a problem with that.
Now, if you're accepting Cubs tickets for somebody who says, I may or may not be able to get you a job, that's the same answer. Or,
Elyse, let's you and me go to the Cubs game today. They're playing at 1:20, and we can talk about that new job that I've got. And you know, I want to talk about the fee, and I'm sure that that you can give me a good rate or a good fee.
Because I'm getting you out of work on a Wednesday when it's 80 degrees here in Chicago.
Right. That would be an interesting question, but I would say the answer to this question, thank heavens, is not that difficult. I would say take it and enjoy.
All right. Well, Kevin and Elyse, thank you so much. We appreciate you guys helping us out. Thanks everyone for listening. Quiz done by Monday, PDH is out by Tuesday. Want to remind everyone this webinar will be recorded and will be available for purchase on our website by Monday. Ethics Part 1 is available for purchase now on our website. I think that's all. So we'll see some of you guys next week for Indiana statutes.
Thank you very much.
Thank you.